want to thank everybody for coming today. We think that this Inventors Summit is really something that's necessary to be a part of the patent debate, but I really want to thank Edison Nation and USIJ, as long as my organization, Entrepreneurs for Growth, for putting this together and being here today, as well as our inventors, who I'm going to turn it over to Louis Foreman here in a second to introduce to you. But let me introduce myself. My name is Charlie Sauer, President of Entrepreneurs for Growth. We represent small innovators, entrepreneurs, and investors. And as a part of that, we've been active in this debate on Capitol Hill. Louis himself is a prolific serial entrepreneur and inventor. He has more than 12, he has 12 patents to his name. His company has more than 100 patents to its name, and he's CEO and founder of Edison Nation, which is the largest online community of inventors in the country. So there's nobody better that could host this and really help these inventors tell their story. So thanks again for coming, and we look forward to your questions. One quick announcement: there are press here, and so everything that our panel says is on the record. We would like everything from the audience questions to be off the record unless expressly given permission after the event. So thanks again, and we look forward to your questions.
Great. Thank you, Charlie. And it's a pleasure, it's an honor to be with you today. We appreciate you taking time out of your busy schedules to listen to what we have to say. We're an odd group of people here. We're fish out of water. We're not Washington, D.C. insiders. We're not lobbyists. We're passionate inventors who have made a living by creating, by inventing, by coming up with ideas and turning those ideas into successful products and successful businesses. And so we'll start with, to my right, with Warren Tuttle. What I'd like to do is just go through a brief introduction of who we are and the types of products and industries that we're involved in, and then go into a little bit of the background and the discussion around this legislation. You know, I think it's important to understand, and I really want to get it out from the very beginning, is we're not obstructionists. We're not here to chain ourselves to the Senate building. We're here to help in the process. We represent a variety of different industries, a variety of different product segments, and we want to make sure that whatever happens through this process, that independent inventors have a voice, that they're part of the solution, and that we don't become part of the collateral damage or unintended consequences. So again, thank you for joining us this afternoon, and Warren, if you can give an introduction.
Okay, great. Thank you. I'll start. My name is Warren Tuttle. I wear a couple different hats. I'm the president of the United Inventors Association, which is the largest nonprofit in the U.S. dedicated strictly to inventor education. And then I also run the Open Innovation Program for a couple of large U.S. companies, which is the goal of having companies reach outside the company walls for new ideas and products. I've been involved in the launch of over 100 products and probably more businesses, and I've had 6 or 7 incredibly successful products. One of them is Misto. Anybody use Misto at home? Olive oil sprayer? One of the great products of all time. Have sold over 10 million of these, okay? By the way, I didn't have one of these an hour ago, but I dropped by Bed Bath & Beyond and they were at the register. And then this is the odor-absorbing splatter screen, which we sold over 3 million pieces in the last 2 years at retail. I have several others. But the bottom line is that I work with inventors. I probably talk or email 15 inventors a day, 50 a week, thousands a year. And the spirit of America is still alive. These are independent inventors who believe in the system, and they just need access to shelf. So that's what I help them do, and I'm here today to help Louis and the gang here to try to remind everyone that the patent system dates back to the early days in this country, and before we change it, we should think very carefully about it. Thank you.
Good morning. My name is Griff Neal. I'm the founder of NCAP Technologies. We're headquartered in the San Francisco Bay Area. We have a manufacturing facility outside of Chicago, Palatine, Illinois, that employs about 160 people. Our work is making electromagnetic cores for high-efficiency motors and generators. Our customers are companies that produce things like clothes washers, air conditioners, furnaces. We also are very active in industrial components, conveyor systems, robotics, again, because the technology we developed makes things more efficient, uses less electricity. I think what we're probably most known for is our work in the auto industry. It's our belief that every single hybrid vehicle produced in the world today uses technology that we created. The reason I'm taking some time out of my life, 2 days here in Washington, I don't do this kind of thing normally is because I am very concerned that an unintended consequence of the new legislation that's going to be enacted will be the loss of jobs at manufacturers, companies like mine. We'll talk more about that in a few minutes. Thank you.
Good morning. My name's Richard Himmelstein. I'm an individual inventor from Colorado, Breckenridge. And I have more than 50 patents and applications on everything from social networking, vehicle telematics, financial trading, and smartphone technology. I'm also very concerned about patent reform. American Invents Act, I supported, and I felt it had a lot of good things in there for everyone, and I'm just concerned that patent reform is moving very quickly right now. And I'd prefer to see changes done with the USPTO with them getting the proper funding versus moving towards patent reform until we see how American Invents Act affects everyone.
Hi, everybody. My name is Marty Mays. I'm a founder and chief technical officer for a startup company in Minneapolis called Hilera. It's a medical device company that is developing new technology for the treatment of patients with a disease called COPD. It's a disease that kind of encompasses things like asthma and emphysema, as well as chronic bronchitis. Affects a couple 100 million people worldwide and can be very debilitating. Prior to that, I was a physician and an engineer even before that, and I was a professor at Washington University in St. Louis, and it was there that I started kind of developing new technologies, new devices, and new procedures to help my patients, and some of them I felt could help other people. So about 5 years ago, I'd taken one of those ideas and developed some patents around it and made it, tested it, and built a company around it. We currently have about 31 full-time employees, 15 to 25 people who work full-time for us at other companies. And we're right now in the process of closing our 4th round of financing. So as a private company, we are financed. We are developing something. We don't make or sell anything. So every penny we spend is a penny out of our pocket or out of our investors' pockets. And I've been at this 5 years. It'll probably be another 3 years before we have the opportunity to sell something in Europe or in the United States. And it's very important in that process for us to have patents that can protect our idea, can allow us to develop it, and can make us attractive when we talk to potential investors about what we're doing. I think with our current round of financing, the thing that has struck me the most, I guess as a physician, was companies that were looking to invest in us spent as much time on whether we could protect our idea and whether they could protect the market if they were to invest and acquire us, as they did on whether the thing worked or not, which was really odd, but there was a lot of attention paid to that. And strong patents, I think, are really important to make that happen.
I'm John Morris. I'm one of the founders of 12, a startup medical device company in Redwood City, California. For me, it's been a repeated process of joining small companies in their infancy, even before they really have a name, and working closely with physicians and other engineers to develop these new ideas into medical devices. Real products such as balloon catheters to treat sinus infections, chronic sinus infections, by gently remodeling the anatomy, or a kid-friendly procedure for placing ear tubes that doesn't require your child to be on an operating table under general anesthesia, or tools for hip surgery that eliminate the standard equipment, which looks like torture racks. And soon, a replacement heart valve, something that will avoid the need for open heart surgery, something that will help patients return to an active lifestyle without the risks of stopping their heart. In this process, which is long and expensive, patents are key to our ability to raise funds from investors and develop these ideas into real products with real patient benefits.
Hi, I'm Eb Bright. I'm an inventor and an entrepreneur in Northern California. I work at a medical device incubator where we create new medical device companies and then spin them out, get them financed, and we continue to support them as they grow. I've been a co-inventor on a number of technologies, some of them related to doing bariatric surgery in a less invasive fashion, some of them for doing treatments of osteoarthritis of the knees, also a device, the only one that's small enough that I could bring it easily here to help reduce snoring and or sleep apnea by holding on to the tongue as you sleep. And behind all of these companies are venture capitalist investors, and behind them are limited partners, and behind those limited partners are retirement funds or college savings funds. And when those people make investments in our companies, what they are relying on, and just what Marty mentioned, is a strong patent deterrent to those who would come in and, whether it be foreign competition or local competition, and take an idea once it's proven that it can be done. And so we want to make sure that we're very careful that we keep the appropriate balance in the patent system so that we're able to continue to drive new innovation, in particular fundamental breakthrough new technologies.
Hello, my name is Chris Hawker. I'm the president and founder of Trident Design in Columbus, Ohio. We employ 16 people. I'm an inventor, and I invent things. Here's one of my products, is the Power Squid. It's a power strip with flexible outlets that easily accommodate bulky charger plugs. And here's another one. These are onion goggles, so you don't cry when you chop onions. So we invent everyday objects that improve people's lives, and we help inventors do the same thing. So about half of what we do are develop our own ideas, and half of what we do is help people, everyday people like you guys, have ideas, and you're like, what do I do with this? How do I make money from this great idea? And the way you do that is you file a patent, and then you get someone else to make it, because you've got day jobs that you want to keep. You don't want to try to figure out how to go to China, get things made, how to sell to Walmart. These are things that are not fun to do for normal human beings. I don't recommend it. But if you have a great idea, you can actually make money from it by getting intellectual property. And then the companies that are hungry for new products to sell come to us looking for those ideas. And if we collect a 5% royalty on the product, that means the actual wholesale value of the products is 20 times what we're getting paid, and the retail value is another 2.5 times that. So if we just do $1 million in revenue, we're creating $50 million in economic impact on our society. So what we're doing is important, and it has an amplification effect that creates a much bigger impact on the economy than just our business and the people we employ.
So I'm Jim Bauer. I'm actually a computational neurobiologist, but that's not explicitly why I'm here, although the first thing I patented was a technique for recording multiple neurons simultaneously in brains. I don't think, no one here I think is wearing that, I don't see. Anyway, however, the reason I am here is that I've also been involved in STEM education for a long time, many, many years, and was one of the first people to start building games for learning in 1985. And in 1999, I started a company, Numedian, which launched the first virtual world for children. In fact, it's the first browser-based virtual world ever, called Yville. Anyone know Yville? Okay, anyway, we have 7.5 million kids at the moment. We filed a patent in 2001 for the technology. It was a very broad patent because we invented a lot of virtual world commerce interaction. It took 11 years to get through the PTO. We now have it. And now we're pushing in the litigation side, or at least asking people who now use our technology, which is very broad, all over the place, major media companies everywhere. So we're getting into the side of how you actually enforce these. And I'm deeply concerned that some of this legislation that seems to be being pushed through at a very rapid rate at this point, especially compared to the last time you did this, when there was some time spent figuring out the consequences, that one of the things it's going to do is further tilt the field, so that the playing field, so that people like us are at an increased disadvantage with respect to people that have large numbers of lawyers and large amounts of money to protect themselves against us. And I'm deeply worried about that.
Hello, my name is Eric Huber, and I reside in Orange County, California. I am, like many up here, one of those true garage inventors, or many of them started that way. And that's what our reason here is, just to put a face on the hundreds of thousands, if not millions of people out there like us that have an idea and then do something with that idea. Many of my ideas are not life-saving like some of these guys, like the squid, the power squid. Mine tend to be more consumer products. I have items as seen on TV, but I might be working on a revolutionary way to desalinize water, or a way to help women zip up their dresses by themselves. So, that's the diversity that we come from. And so I don't have the skill set, I don't have the resources to take these different ideas to market. I rely on others, and my process is I license these products. I mean, I have hundreds and hundreds of products in here, many of which I've luckily found homes for. And because of my ability to acquire a patent or to have that protection, is changed my simple idea into an invention and ultimately into something that a company is willing to invest in and commercialize. My fear is that, and I don't think anybody who supports the legislation wants to hurt us, but there's a lot of unintended consequences that I think that my wish is that we just kind of slow down and just listen to all sides of this issue. And thank you.
I just wanted to briefly say before turning it back over to Louis, thank you to Congressman Rohrabacher, who is here. You've been a good champion of fundamental patent rights and intellectual property, and we thank you for coming to listen about a very important topic.
Thank you.
We must succeed, or we're never going to get it back. Remember, this is it.
That's right. Well, and that's why we're here. We're here because we're concerned. We all have day jobs. We all have other things we could be doing today, but we actively engaged and organized to come here to make sure that we could share with you the concerns that we're feeling. In my story, I'm an entrepreneur. I started my first business in my college fraternity room 27 years ago. I've never been an employee. I've never held a job. I create jobs. And all the companies that I've created over the last 27 years are anchored by intellectual property. The ability to protect something gives me the incentive to go out and risk dollars to hire people and to create. And in my business, I don't manufacture anything. My company designs, we invent. We invent new products, we invent new services, and we license those products and services to other companies that are good manufacturers, that are good at distributing, that are good at marketing. So in many respects, you could call me an NPE. I'm a non-practicing entity. You could call me a troll. In fact, you could call all of these people at the table here trolls, because what we realize is we have a property right, a patent, and we're not good at manufacturing something. So in many cases, we recognize putting the product in the hands of others who has the same effect. And so our concerns are this slippery slope, that there's no turning back. That when you start to water down the value of a patent, and when you institute all of these procedural processes that slow down the ability to recognize the true inventor and to seek justice, you're eliminating the incentive that we all took to create in the first place. If we can't generate some form of economic return for our activities, then the incentive isn't there for us to create at all. And so when we talk about patents, I think patents mean different things to all of us. But Eric, why don't we start with you? As a small inventor, how important is a patent to you? And what are you hoping that patent is actually going to deliver?
For me, a patent is absolutely crucial, again, because of being a small independent inventor, I don't have the ability to manufacture, nor do I have the ability to even defend my own patent. So I rely on having that IP gives me power. It takes my idea and it gives it value, and it formalizes the value of my idea, and it gives them an incentive to work with me. In many cases, many of my products go forward, and the licensee decides not to put a patent on it. And often the case is because they know the reality is that sure, they can get a patent on it, but they can't enforce that patent. And my fear is that this is going to make it even more costly for myself, for small and medium-sized companies that I work with, absolutely to defend that patent.
So John, you're on the opposite end of the spectrum, where Eric is involved in developing very simple consumer products that people like to buy. You're involved in products that have a much longer gestation period. How important is a patent to you?
Sure. In the medical device world, it's a long and expensive process to turn these new ideas into safe and effective devices with a therapeutic benefit. You hear about startup companies and you hear about social media or software, and it's a pretty quick hit. Not so for us. It often takes 8 or 10 years of development before we get our first sales. It requires a huge investment, 10 million minimum, 50 million, 100 millions of dollars before we get our first sales. Along the way, we're building up large teams. At a Clarent, where Eb and I worked together, we started off with a handful of employees, and 5 years later, we were 300 employees, just to turn these ideas into products. To get that funding, to get that investment funding, we need strong patents. I'm concerned that the legislation under consideration has the effect of weakening that patent protection. And if so, that would make it a lot more difficult for startup companies like mine to turn these ideas into patient benefit.
Marty, in your business, you've actually created jobs as a result of your intellectual property. Just tell us a little bit about that.
Yeah, so founded the company about 5 years ago and kind of moved it around the country. You've ended up in Minneapolis, which is where most of our job growth has happened. The first few years, we're proving the concept. In the last year, we've gone from about 5 employees to 31, as I mentioned earlier. And it's very interesting. We moved to Minneapolis because there is a rich culture of medical device development and manufacturing there. We moved there because of a lot of the larger companies that have trained these people to do medical device development have been laying them off. So when we moved the company there, every person that we hired used to work at one of the larger strategic companies that are in Minneapolis. So I think we have developed new jobs for people, and a lot of them have come from larger companies, maybe the incumbent organizations that have been laying them off.
So we know a patent prevents others from making, using, or selling something. It's a property right, and it's fundamental, again, to that incentive that we have to go out and create. But unfortunately, sometimes the only way you can protect a property right is to go against infringers. And so we all have been involved in some case of infringement. Griff, in your business, have you ever run into that situation?
Unfortunately, it occurs almost every day for us. Our customers are very, very large conglomerates. They'll infringe if it suits them. And so it's a balance of power thing from my perspective. Big companies typically aren't suing one another. You don't see GM necessarily suing Ford as an example. It's the big ones and the little ones that get into disputes. And if I can tie it to the job issue, little companies tend to employ domestically. Big companies, first card in the infringing playbook, move the production to someplace else with lax intellectual property laws. Perhaps that's China, perhaps that's Brazil. Makes it difficult for guys like me to figure out what's going on, but more importantly, it exports not only this device, but probably where the things this device goes into are also produced. So if I can drive that to an example, most clothes washers sold in the US today use technology my company created. The motors that spin the tubs and the motors that power the pumps to squirt the water and take the water out. That's the high value add in the washing machine. When all of that gets moved to a country like Brazil, then they'll put the rest of the washing machine construction down there, so you lose the job multiplier. So it's not the 160 jobs in our manufacturing affiliate, it's all the other stuff that sits behind it. So specific to the question, I see it as jobs, but this legislation right now appears to diminish the power that we have in negotiations with our customers.
And Richard, in your business, you've got quite an extensive portfolio of intellectual property. Have you been in similar situations?
Yes, I have. For example, I had a social networking company. I was working on it before Facebook existed, before MySpace, before Friendster, and I recently shut the company down, but when I went to monetize the patents, I approached some of the companies in the space, and they weren't interested in licensing the patents, although it was clear infringement, and it was a very frustrating experience.
So this whole dialogue has been around trolls and painting this picture of this bad behavior. And I think it's important to understand that it's not so much about trolls as troll-like behavior, that the vast majority of our industry don't litigate. How many people here have litigated against an infringer? 2. So how many demand letters do you send out to companies when you find that they're litigating or that they're infringing? 1.
To the OEM.
We're not sending out excessive demand letters. We're not using litigation as a way to generate revenue. We see it as kind of a last resort. It's the last piece of recourse we've got if we can't come to terms with a license. Most inventors are inventing, and they're trying to monetize their inventions through the right process. And so there are clearly bad actors in our industry. There's bad behavior. It's despicable behavior. Our concern is that this litigation goes, or this legislation goes too far, that it sweeps in groups like us, independent inventors, who rely on invention for a living, and we are the collateral damage. We are the unintended consequences of something that is so far-reaching that, well, we'll take care of the big industries, and if a few independent inventors are hurt in the process, that's okay. And so what ability, Chris, you've been involved with a lot of consumer products. When you come across someone that is infringing, what do you do?
Send them a cease and desist. And if it's a retailer, like we had a situation with the Power Squid where a major retailer was selling a knockoff. So one of the legislative topics is the customer stay provision. And in that case, if we send a cease and desist to the retailer, then they would just say, well, you can't come after us. They can go after the manufacturer, who in this case was a Chinese company. But meanwhile, the retailer had induced the infringement by requesting the knockoff of the product. So at the time, we were just able to send a cease and desist. They took the product off the shelves and replaced it with our legitimate product, as opposed to under the new proposed rules, there would be no there. They would say, go after the manufacturer. And then I'm a small independent guy. I don't have the legs or the wherewithal to attack someone in China and go after someone in that way. So it's having the ability to go after the people actually selling the product is vital to my ability to enforce my rights in the product and give me the incentive to create it in the first place.
And Jim, in your business, took you 11 years to get your patent through the patent office. So clearly it's a good patent because a lot of review went into it. But do you face similar challenges?
Sure. I actually think, and I raise horses in Texas, so I apologize for the analogy, but I think a lot of this is misdirected. I think a large part of the problem is actually the way the PTO operates. You're trying to fix something after the horses are already out running around that haven't been bred properly. You need to look at the PTO, fund it sufficiently, educate it, so that the bad stuff doesn't get out there that the trolls can use inappropriately. Putting a Band-Aid on this after it happens, and I know a lot about that because we've spent 11 years educating the PTO about software patents, and that's only beginning. One of the solutions I've heard a couple of times is, for example, the software patent thing in particular, is we should just simply ban software patents. Well, in my view, that's equivalent to banning metal at the beginning of the Industrial Revolution, because some people might have put together patents which were inappropriate. But if you're banning the thing that it's made from, you're also banning the appropriate. But understanding the difference between software patents that are really fundamental in inventions and those that are, sort of silly, requires you have a functioning PTO, and that requires that it actually be funded. For example, just basically based on the amount of money it raises. And I don't see much focus there. Let me mention one other thing about my particular situation, which adds a little. Inventors are all interested in getting their return on investment, so money matters. In our case, we invented technology to educate children online. That technology is now being used by others to exploit them. okay, to figure out how to get at their parents' pocketbooks by using in-game purchases, for example, by setting up special classes of users. You can only be that user on this virtual world if you actually pay a fee every month, okay? So not only is it annoying that they are, publicly acknowledging using our technology, but they're using it for purposes that violate, the original reason we built it. The only way now that I can, unfortunately, because of the way the system is already rigged, I think it's already rigged in favor of the big guys. This law, that what I've seen going forward here is going to make that worse. I have little choice but to work with patent assertion agents, organizations, because I don't have 100 lawyers and I don't have $10 million to go out and fight Viacom. I don't, okay? So I need to work with them. The effect of increasing the cost for the patent owner in this system, which I think in every case that I've seen of these different components of this law is what's going to happen, that actually, it's not going to put the patent trolls out of business. It's going to mean that they're going to get a bigger percentage of my value in negotiation with me for a license. They're going to say, look at the risk now that this law is added on. They're not stupid. They're just going to pass this down to me, and instead of getting 5%, I'm going to get 2%. Or worse yet, they're going to say, sorry, that's too imaginative an invention. It's too risky for us. Forget it. Okay, so I think, I think this is going way too fast. I don't think we've been at the table. We were at the table last time around. I don't think we are now. I don't completely understand the politics in this and why it's going so fast, but you're messing with something that is really vital, if it's true, which you hear all the time, that the world is changing, we're in a disruptive environment, and it turns out that small inventors are the ones that are going to generate the value for the future. Please make sure that you don't add huge overhead to us to do this, or we'll simply get out of the business and the invention will move somewhere else.
If I may, on that, just the source of innovation. My company's regularly hired to beat patents. Someone hires us to say, here's something we want to create a product to compete with this. How do we get around their patent? And the way we get around their patent is by innovating. If you knock something off and just make it the same, that's called a knockoff. If you knock it off and make it better, that's called an innovation. And so because of the patents, we're required to be very creative, to come up with things that deliver more value to consumers than what they had before. If you weaken that disincentive to copy, then you weaken the need to, companies will take the easier path of just creating things that are more like what we already have, and things stop getting better as fast. It's a virtuous cycle. I call it the knockoff effect. The knockoff effect is good for society, actually. It causes the cost of innovation to come down as knockoffs occur, and then you have to come up with new things. And if you eliminate that, at least in that legal aspect of it, then you make it much easier for people to just take the easy path, copy what you've got that's already working, that you invested in figuring out, and then they can just roll with it. And it leads to a harm to all of society, because these innovations aren't all just onion goggles. Some of them save lives. A lot of them save lives. And so it's not just a financial thing. It's actually a quality of life thing. It's a duration of life. It's it's education. It's all these things that are very vital to our society and where we're going as a culture into the next 20 or 30 years.
That's a great point. And so through this process, and we are definitely late to the game. So we did not initiate this, but we're here to make sure that you understand that there are these unintended consequences, that our industry is concerned. This is just a small representation of the independent inventor community. We delivered a few weeks ago to many of your offices over 2,100 signatures and 2,100 individual letters from other independent inventors who would be right up here if we had a bigger room. But the point is, we're concerned. We don't want to obstruct the process. We want to be part of the process, and we want to educate you on how our industry works, how we extract value from a patent, and how we aid the economy and how we aid society from our inventions. And so Richard, last night Richard and I were talking a little bit about his inventions, and very prolific inventor. he licenses his products. But what happens sometimes when companies don't want to license from you?
It's really amazing how they're bean counters. They look at the situation and say, how is this little guy have $10 million to fight? Are they going to do anything? And I really see a propaganda machine on the other side, and all this legislation I see moving forward is really eroding the property rights of patents, and it's going to have a very harmful effect.
So we've tried to be constructive in this process. A lot of information has not flown out to us, but we did provide a markup, a red line markup to Senator Leahy's bill, just offering some nuances to the words. Not saying that this is terrible and you shouldn't do it, but trying to close some of the loopholes and offer suggestions on how to address some of the problems. And customer stays is one of those areas that we have concerns because in many cases you don't completely understand our business. We totally understand the little coffee shop who goes to Best Buy, buys a router, plugs it in and offers Wi-Fi, should not be sued, should not receive a demand letter. That makes perfect sense. They're buying it for the intended purpose of that product. But what does happen sometimes is that customers will engage a manufacturer overseas to produce a product. And if we have to go chase that factory in Shenzhen to get them to stop, and then they just move the injection tools to another factory, that's going to delay the process. Or in some cases, you may find that multiple companies are manufacturing parts that don't infringe, but when you combine and assemble those together, that's where the infringement occurs. Having to go after each one of those factories individually, again, delays the process because the real infringement is occurring when the assembly happens. And certainly retailers aren't always the innocent parties here. Most retailers are very reputable. They buy legitimate products. But today, retailers are doing a lot of private label. If you walk into any retail store, you'll see they've got a lot of their own brand. Well, they don't have teams of product developers on staff. In many cases, they just find a factory to make a copy of something. And sometimes, inadvertently, they infringe. And so we need to have the ability to go after the real infringers when that occurs. So we've offered suggestions on how to tighten the language to make sure that all parties are taken care of in this process. But I think what really scares us is the litigation side of it. You know, loser pays is something for a small independent inventor, scares us. It keeps us up at night because litigation is a last resort for all of us. If we ever get to the point where we've got to litigate, that's because we've exhausted every resource out there already. We've sent letters, we've talked with them, we've tried to reason. And if all of a sudden we are on the hook for not only our bills, which we can barely afford to begin with, but also the other side, who now has a vested interest to run up the bills, that's a denial to justice. It's something that we no longer have, and it forces us now to settle at something that's artificially low, at a dollar amount that we should have gotten more if we had access to the legal system. So, Warren, you talk with a lot of inventors. The UIA has 15,000 independent inventors. What do you think the impact would be to inventors if legislation like this went through without any sort of compromise?
Absolutely dramatic. And just going off of the Goodlatte bill, when we polled our membership, and we got a fairly healthy response, it's not entirely scientific, but we basically laid out the Goodlatte bill. 75% of the respondents said that they would either stop inventing or seriously curtail. Now, if you get the independent inventors to drop out of the process, and then you have these joinder issues, which means anybody that's supplying capital or resources to help the inventors, and they're taken out of the process, this is a very effective first step in ending the patent system as we know it in this country. So it's rather dramatic and it's serious, and people have got to take this very seriously.
Can I just explain that quickly? These are very special times. You know, transformation is really happening in the economy. Now is not the time to suppress independent. You know, you can look at this situation, one way to look at this thing is sort of conspiratorial, is that the people that have benefited over the last 10 years from disruption now want to make sure that the next set of disruptors don't disrupt them. So they're gaming the system so they stay in the privileged position they're in now. That's okay if everything's stable, but nothing is stable. I mean, Facebook is the first effort to figure out how to do this on the internet. You need the next set of investors to come up. Google is the first shot. They haven't figured it out yet. You need to allow the independents to be able to come in and threaten them. And they're going to try to protect themselves. That appears to be what they're doing. But it's an error for the economy of the country. It's really a historic error at this particular point in time with respect to technology, to sort of freeze things and freeze us out.
So we understand that there is a sense of urgency to do something. We understand that the Congress wants to move something out. But there are other things. In fact, the Feinstein bill, Eb, maybe you can speak to that.
Yeah, so one of the issues that's developed over the years was the diversion of fees from the Patent Office. And you have to feel for the employees over there. I mean, they have 700,000 patent applications sitting in a backlog waiting to be addressed. I think at the time there was only 4,000 of them to handle that workload. And they're trying to do what they can to do a high-quality examination, but also do it in a timely fashion. Because if you think about, in particular, one of their fundamental goals is to help new small companies get going and to exist. And think about your own budget at home. You know, you have a fixed rent payment, you have fixed amount of electricity and gas generally each month you pay. So you have bills every month that you pay. And you rely on a steady stream of income coming in for that, right? As a startup company, we get to go and get money, or as an individual inventor, one time from our friends and family or from venture capitalists. They give us, let's say a venture capitalist invests in a medical device company. They give us $12 to $15 million. That has to last us for 16, 18, 24 months. If the patent office sat and looked at every single patent application and took 11 years for it to exist, we would be long since out of business. So they were trying to do the best they could to respond to us quickly, because in order for us to get additional capital, we have to have patent protection. And so they need to do things quickly and also more substantively. And so we need to put an end permanently, forever, for fee diversion. The Patent Office is fully user fee funded. Every time they've ever asked to raise their fees, the inventing community has gone along with it. We say, yes, we want you to do a better job, we want you to do a faster job, and we're happy to step up and write bigger fees in order to get that. But unfortunately, over $1.2 billion was directed away from the Patent Office for many, many years and put them in a huge hole. That was our money that was supposed to help us move forward and exist. So Senator Feinstein has finally put forth, we hope, an amendment that will forever end fee diversion, and it should fundamentally be part of any patent reform legislation. You know, going back to the analogy of the horses, where we need to address this problem is at the beginning. We need to address it in the Patent Office so that there aren't the opportunity for abuses later on.
So we've tried to touch on some of the issues that are disturbing and concerning to us, but what we really want to be able to do is hear from you and be a resource to help in this process. Maybe specific questions that you're facing in your state or that your senator is unsure of, and maybe turn this around a little bit and answer your questions. So I'd like to just invite you to throw questions up to either specific inventors or to the group in whole, and we'll try to answer those questions for you.
I do think we do a horrible job of marketing and have, in a way, lost that argument because of the word troll. I mean, once that label sticks, I mean, it's just a patent owner. You have a long way to go. And a quick experience, I had a company that I worked with, I'm a patent attorney, developed a portfolio for them, and a company, you could say they were a troll, came and offered them $10 million for the portfolio, and they considered taking it because they needed an infusion of cash, and they were offered that much because the troll, which was just a non-practicing entity, studied the market, and saw that a lot of people were in that space, it's cloud computing, and felt like there was a lot of value there. And so when you attack trolls, you're attacking people that might be giving the founders and the practicing entities value. And anyway, so my question and comment is, how can we change the marketing of this whole argument to essentially try to get rid of the word troll?
I'd like to answer that if I can. I'd like to answer, excuse me, I'd like to answer that if I can. From my perspective, what a patent is a right to choose where something is made or who makes it. You can prohibit other people from practicing your invention. This has been marketed as a way to make money. Most patent holders use patents to be able to make things themselves or to choose who manufactures, and that's what I find so particularly frustrating. I don't want to go out and pick a company. I just want to say to them, hey, let me have a shot to manufacture this thing. And I get that you're going to need other suppliers, and let's just make sure that you don't put it someplace where they're going to then take what we've taught you and do it with other customers of ours. So to your question, I think the dialogue needs to be reframed as a right to choose where and how something is produced.
And I think going to your point, it's not necessarily about trolls as much as it is trolling behavior. And it's a very, very small percentage of our industry. The vast majority of our industry are reputable businesses that see their intellectual property as the ability to decide where something's manufactured or the ability to produce it themselves. But when you start to frame it as anyone who has a patent is someone who's out to extort others and take away some unfair value from what they've created, is just a bad argument, because there was a lot of risk and a lot of investment that went into creating that property right to begin with.
So here's a funny story. So I am a practicing entity. Yville has been running for 15 years and on top of our technology, okay? I just created a non-practicing one, Virtual Worlds IP, which I'm also CEO of. The reason is because the whole system is currently so tilted against us that my investors in the core practicing company don't want the risk. So I need to build a non-practicing entity in order to protect, our IP in a way that my core investors are comfortable with, okay? And also, because of the way the whole system is tilted now, I need expertise that I don't have as an inventor. I need to be able to have people like you, and you're not cheap, come in and work with us. You live in Washington? Anyway, so I live in rural Texas, so cheap is cheap, and you ain't it. Anyway, but the point is that I'm being forced to do things I would not want to do because of the way the law is now. And we can go through point by point, and I think some of the document you have is point by point. Each one of the things you're talking about doing, the fees game, okay, the game about who you can and can't sue, okay, the discovery rules, all of those things add to my costs and also add to the expertise that I need to fight against people that have 150 lawyers that all they do all day long is either file patents or chase people. So I don't think that this legislation is going to have the intent. I think it's just going to require a recalculation by the current patent trolls, if you want to call them that, or the patent assertion people, which reduces my leverage with them as an inventor, okay, increases my costs, and greatly increases my risk. I mean, they can now, according to the new rules, they can come after us even though we've licensed our patent to somebody else, right? Because they're going to collect everybody together that has any, quote, monetary interest. That just raises my risk tremendously. So I would like to suggest that someone stop and think. I mean, if you're going to do this, do it, but make a tunnel for us. Make some way that a company that has 15 employees, that has 5 patents, that doesn't have attorneys on, but are the lifeblood of innovation in the country, a way that we can get through the patent office in 6 months without paying a big fee to get accelerated review, a way that we're protected from the 150 lawyers who are perfectly happy to spend 6 years for us and a lot of money to chase us around in court. If you do that, I don't think you're going to do it. Okay, sorry. But if you did do it, you are providing a mechanism to drive innovation in this country at a time when innovation is critical. And if we screw up, there are others. My wife is Brazilian. Okay? The Brazilians will happily do it if we screw up.
Other questions?
I have a question kind of built upon the last thing he was saying. Right now the U.S. is in trade negotiations with Asia-Pacific countries, the TPP negotiations with the EU, so-called TTIP negotiations. And in those and in all of our other trade negotiations, we're advocating, we, United States, for strong IP protections and the importance of intellectual property to our trading partners and to us. So it's surprising that this debate, it seems like we're going the other way. We're discounting the relevance of innovation and intellectual property. So I'm curious as to thoughts on that disconnect.
Let me just jump in there for a second. That's a great point, because I've lived around the world, and one of the great things about America, especially when you view it from the outside, is really the combination of creative new ideas with capital in order to launch it. And that's what this country is all about. And this is this takes away from that. And it's been my business the last couple of years to go around to large companies and actually convince them that it's in their interest to go outside their walls to find new ideas. Because imagine a large company that has all the cubicles and there's a boss going up and down. We need a new solution to this, drive. That's not how innovation happens. Innovation is organic. And when you have the great organic ideas that come out of the hundreds of thousands and millions of sort of garage inventors and so forth, that then gets weeded through the process where capital is put behind them. That is America. This is not America, what's happening here with this bill. And the Goodlatte bill is not America. And we're the shining light. There's no innovation and you will see the adverse effects of this if that bill goes through 10 years, 12 years from now. When all the buffalo have been shot, we'll go back and say we wish we hadn't done it.
If I could just make a quick comment. The U.S. used to be the main place that everyone wanted to innovate. Foreigners, everyone wanted to file patents in the U.S. And with this reform on the horizon, it's really discouraging that foreigners aren't looking at the U.S. as the first country to file their patents in. I know I'm discouraged too.
The term that comes to my mind is feature creep. Feature creep is what we call when we take a design or a product that works pretty well, and then we add unnecessary features to it as part of the upgrade. You see this all the time when you get the annoying notice that your software for your phone needs to be updated, right? You get one or two good benefits and a whole bunch of junk in there. Our patent system, by and large, kind of falls into that category for me. It's strong. It helps us protect our intellectual property, helps us protect our ideas, turn those into products. Let's be careful what changes we make to this.
Congressman.
First of all, where did the word troll come from? It came from a meeting of very powerful people in the electronics industry sitting around the table on how can we screw the little guy. And they had different names. They had come up with one guy who was in the meeting told me, I came up with patent pirate. But no, patent troll sounded much more sinister. So they went with patent troll. This is, and these things that you're describing, this is not a mistake. This is a design by very powerful interests in our country to steal from you. And they have put millions and millions of dollars into campaign contributions over the last decade, 2 decades, in order to accomplish this mission. It's not an accident. If they only realize how bad this is going to be for the inventor, they know how bad it's going to be. This is a fight for power and wealth. It's a grab of power. Mine was the only amendment that passed over on the Senate side to the Goodlatte bill. Well, what was that? What were they proposing? They were going to eliminate your right to go to court as Americans. You have always had that right to say that you weren't treated legally by a government institution, namely the Patent Office. Now, what does that have to do with anything about a troll? What does any of this have to do with the troll? It has things to do with weakening you against them, and them are big, powerful people who are out to screw you.
That all started in their garages.
Yeah.
They are us.
Yeah.
I mean, that's the funny thing. They are us.
And let me just note, the idea is I've always been for these, since day one when we got here, they've been trying to, quote, harmonize American patent law with the rest of the world because we traditionally believe in individual rights. The rest of the world's patent systems were created to facilitate corporate use of technology. And those are two different things. And anyway, good luck. I'll be happy to.
I'd love to give you my seat right here.
But listen, this is it. If something, I don't think we can stop it in the House side. So you got to stop at the Senate. Every university in this country should be calling up their senator saying, you are attacking us if you pass this, because they will pay attention to your universities. And there's no going back. I mean, once this passes, you're not going to recapture these rights that have been taken away from you. So I encourage you to be as tough as you can in the next few months.
Yeah, but we've heard that the game's done. We've heard it's being marked up on Tuesday. There's huge momentum to pass it. Basically, the fix is in, it's going to happen. Is that not true? I mean, is there really a chance to bring some sanity to this?
I would suggest that if you got every major university called up their senator, they would delay this. And we know Feinstein understands that because some work has been done in that. But if you do that, yeah, if you would call up, make sure you get a hold of all of the universities in every state, and they will listen. Your senator will listen to those university people. So, because this will be a disaster for them, as you know.
My impression is they don't know. I mean, this has happened so fast. I mean, I'm a professor in 3 universities, actually, at the moment.
Well, they need to be called today.
Yeah.
They need to be called today because...
I'll say, I work for Senator Levin from Michigan, and University of Michigan is very involved in this, and there were some briefings on the Judiciary Committee that they asked us to go to, and they feel like they've put forward some suggestions to the draft. I don't know if they've been, where if they're accepted or not, but they are weighing in, at least that big research.
Well, we need to make sure every university does that because what this is, their definition of patent troll would even include all the universities. Every university would become a patent troll because they are not developing and owning these patents specifically for commercialization. And I went up to not JPL but Jet Propulsion Lab and Caltech. I went over to Caltech and had a long talk with them, and they're aware of what a horrendous outcome this will be. This is your moment. Don't get, and just nuances and things like, this is the battle, and it's blatant, and it's corrupt. We have a corrupt system. We have a system where big, powerful people can give donations to everybody on the committee, just the maximum amount every year. They're not saying they want to promise, but by the time these votes come up, the people on the committee know who their friends are. And they don't hear from the small guys because the small guys don't have that type of ability to give those bucks over a 2-decade period. So the little guys got to stand up now or we're going to lose our freedom.
Well, I have 7.5 million children, and we actually train them to be entrepreneurs. So I was thinking about going tomorrow and asking 7.5 million of them to call their senators and say, please give me a chance.
Yeah. Well, thank you very much. Pardon me.
And we appreciate that. That's encouraging. We're obviously underfunded, not well represented, late to the game, but what we're hoping is for those of you who are off committee that you share this information with your senator and explain to them that it's your constituents, it's the ordinary people in your communities that are the inventors. They're the idea people, and they're going to be the ones who are going to be discouraged and impacted the most by this legislation.
Hi, my name is Jordan. I'm a student of the law, patent law at Georgetown, and I worked at a law firm doing defending or prosecuting patent non-assertion entities, and now currently work at the International Trade Commission protecting America from bad patents. My question is, and I support what you are doing, my question is over the fee shifting provision. The provision says that it will only be shifted if it is objectively reasonable and substantially justified. Clerking for the Honorable Judge Lord at the ITC, judges know when a patent troll or patent assertion entity is doing something in bad faith. But the judge needs some sort of statutory authority to shift those fees and basically slap that troll on the wrist. They need that. Why are you against the objectively reasonable and substantially justified portion? Thank you.
I just have one comment on that, is that with that, there's still uncertainty. And with that uncertainty, there's a lot of decisions are made based on that uncertainty. And in my business and our business, we need certainty as much as we can because there's so much risk elsewhere. So that's the part, that discretionary, part of that. I think it still has uncertainty.
There's a practical point, which is what's the default? If the default is that the loser pays, then the judge has to make a judgment that overcomes that default. If the default is the American system, which is what it is now and always has been, not the English system, then the judge can make a judgment that, wait a minute, this is a troll, I should shift the fees onto them. So the way it's currently written, it's written as you're guilty unless the judge decides you're innocent. And that makes the innocent have a much higher bar than the guilty. So that's the problem I have with it. I think if it stays American law, but you strengthen the ability of judges to say, look, this is clearly a troll, this is clearly a wrong action, this was clearly a harassment, blah, 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 and therefore, sorry, you're going to have to pay their fees too, then that's fine.
So, and as a law student, by the way, where's the historical precedent for this? What other areas is this applied in? I mean, this is a new, dramatic shift. This is America.
Yeah, and that I would add that, it's using, yeah, and, the thing is it's using dynamite to kill something, a fly, basically, so that everybody in the room is destroyed. The reason that the problem exists is because the exceptional circumstances standard that exists, right? You don't need to totally shift the whole burden of proof and the whole presumption that the non-prevailing party is somehow a bad actor. All you need to do is look, like, for example, at copyright law. Copyright law has a slightly lower standard in the ability to shift fees. So all we have to do is slightly lower it from exceptional circumstances to something that's objectively, unreasonable or baseless in the copyright standard. And that would be a much more surgical, targeted approach to the problem. And in all likelihood, we're going to find out in 3 months anyway that that's going to be what happens, because the Supreme Court's hearing 2 cases this term, and they've got a rule by the end of June, right? So we're going to know. So to rush to do this litigation in light of them about to rule on it is a shame. We should be very careful and deliberate and slow down and think about all the impact of the potential changes.
And if the purported purpose of that is to stop patent trolls or harm patent trolls, but the patent trolls are actually well positioned to absorb that because they have people making calculated risks. So they're making a calculated risk. This just becomes part of their calculus. So you're attacking the patent trolls, and to Jim's point earlier, it just shifts their calculus with the people who brought them the IP. They're getting a smaller piece. The troll takes a bigger piece to accommodate their risk. And so you're doing the dynamite to kill the trolls, and what you're really doing is making the trolls stronger. It's like in that movie, Fifth Element, where they shoot the nuclear missiles at the thing, and it gets bigger and stronger, not smaller like you were hoping.
So Chris, we were trying to paint the picture of us independent inventors as being sane and not wearing tinfoil hats. We've gone backwards there. We've got one question in the back.
So my name is Brian Clark. I'm an independent patent attorney, and just some of it preempted my question, all the discussion you just had, but I want to know where the judiciary is in all of this. There's all this, one of the most objectionable things in this legislation to me is the idea that the loser pays. And it's just an abomination. And what I can't figure out is where the judiciary fits into all of this. And why is it that the judiciary has these tools, exceptional case and Rule 11, that they can use, but for whatever reason, they're refusing to use them, or they have an inability to use them. And that, to me, seems to me that they're rushing this legislation forward when they haven't even considered alternatives for addressing those issues. I really think that, at the minimum, they ought to think through these things a little more thoroughly.
I think to Eb's point, we're hoping that that comes out of the Supreme Court.
Yeah, and I think also if you're referring to the judicial branch and where they sit on this, I think, you know, that goes back to the Congressman's comments. I mean, they believe in access to the courts, and they know that if the standard for shifting fees was too low, like it is in the English system, that there will be unjust circumstances that occur. They know that it will quell and it'll deny access to the courts by legitimate plaintiffs, just by the mere deterrent effect that it'll have. And so I think that they've taken a very hands-off approach for the last several decades because they wanted to be able to have everybody have their day in court. And that's why they've had their standard as high as they have. Now, I'm sure that they're feeling a lot of the political dialogue. I'm sure they're feeling a lot of the public discourse that has been funded. And they're going to probably say, maybe we should deny access to the courts but to just a few more people. We're just going to shift it a little bit, but we're going to do it, and I'm hoping they do this, in a measured fashion so that as they start to try to bring the pendulum back to the center point, they don't do what the House is trying to do, which is to way overswing the pendulum to the wrong way and deny access to the courts to a large number of people.
Yeah, it just seems to me that the standards are there that they need to have. They're just not using them. Now, if the legislative branch wants to encourage them to use it more, this is the wrong way to do it. And they really ought to be more readily used them. I agree with you that the pendulum needs to be brought back over, and you don't want it swinging, knocking a bunch of other people over. But they use it so infrequently now, and this is really part of the big problem with trolls. I've defended a number of cases where they were against trolls or troll-like behavior, and they have no repercussions whatsoever. They just go ahead and use the judiciary as though it's their little toy sandbox, and they have no repercussions. I have no leverage representing my clients against them whatsoever because they don't make a product. They don't have any patents to put at risk. Once you put the patents, the only leverage you have is that they have to pay some money. So again, in terms of the legislation that's currently existing, putting in that thing where people have to pay if they lose is like hitting a nail with a nuclear weapon. You know, I mean, it's just a complete overkill.
Well, you add to that joinder so that people who could be pulled into the case that aren't even a party to it, and it's insanity.
Well, if you overlap forum shopping, I shudder to think if, I'll pick a company, General Motors decides they don't like what I'm doing and they decide to pull a suit in Lansing, Michigan. I think it would lead to a lot of preemptive litigation by the big companies who say, I'm going to pick a spot because I know I can really squeeze this guy. Small guys like us, we don't want to get into court. Again, I keep coming back to most of the time all we're trying to do is manufacture something.
And if you look at the provision in the bill, it means they don't have to show their hand. For a small company that's now, you know, considering litigation, for example, or pursuing these guys, they don't have to tell you what's in their hand. Okay? So they string this out for 3 or 4 or 5 years, and then they launch the cruise missile at the end, and you don't know. So the risk to me of going into this whole process without knowing ahead of time what all the issues are, that they can kind of roll them out one after the next after the next. I mean, as you know, just going into the courts is not an even playing field for us. Anything that delays or costs us more money in the courts just further tilts it away from us. And I would ask the question, looking at this bill, is there anything else they could have put in that would have made it worse? I think they got them all. It's very well crafted. I think they got them all. But you know, and I say, I'm a neurobiologist, so psychologically, these guys, a lot of the people that are driving this with the money were us 10 years ago. And they're scared of us. So they want to solidify the position they have. But it's a real dangerous thing to do, especially at this point in the sort of evolution of this economy.
The first thing that we learned is they were trying to sneak through the GATT implementation legislation, something that would have, number one, changed the fundamental thing from after 18 months, your patent application would be broadcast to the world. It would be published after 18 months, whether you had your patent or not. I mean, think of what that would do to you.
Mm-hmm.
And second of all, they were going to say that, end that whole thing where you have a guaranteed 17 years. They said, just like Europe, once they were trying to push this through where if you filed for a patent and after 20 years after that, you have no patent protection, even if it takes you 20 years to get your patent.
Mm-hmm.
And this is what they tried to do. And I managed to fight that back, but this is really what we have right now in the next few days is life and death. And why don't you call my office and we'll get together at a restaurant tonight someplace.
Okay.
Thank you, sir.
Thank you. Thank you.
So we're at the end of our session, although we're more than happy to talk for as long as anyone wants to talk with us about this. Clearly, we're passionate about this, but we do appreciate your time. Just being heard is kind of part of the process, but hopefully this message gets back to your office, and we don't want to end the process. What we want to do is be part of the process, and hopefully more deliberative conversations come out of this, and we get good legislation that doesn't have the unintended consequences of quelling innovation. Thank you for your time.